Commissioners.
Good morning. It is January 30th in Senate Judiciary. You're picking up S12. We have Tim Dumont from the State's Attorneys and Sheriff here to provide some testimony. But before we begin, I have started getting a lot of questions and inquiries about licensing and OPR regarding this bill. For those who like watching Senate Judiciary testimony, yesterday we had a lengthy conversation about this bill, more of an informal discussion that should be on YouTube and accessible. So for those who want to review it, but I believe there's a general consensus among the committee that we're not going to be opening those floodgates regarding licensing. Basically, when it comes to that area regarding licensing, we're going to continue as things have been. And just wanted to put that out there for now. And so with that, Tim, if you want to start your testimony.
Thank you, Mr. Chair. Tim Dumont, Department of State's Attorneys and Sheriffs, Executive Director. And I'm actually going to ask that Kim, if you're okay with it, step into the witness chair as well. She is going to really be our lead on this, but because I have the maybe emotional burden of following sealing and expungement for the last 3 to 4 years, I'm here to help if there's any sort of questions on history or the department's perspective. Contextually, I'll just say, just as a fact point that you can be thinking about as we're dealing with this topic. As of April, so there's been many since April, but as of April 2024, between 2018 and April of 2024, there have been 70,225 sealing and expungement orders. In 2023, there was 22,248 orders, which was more than all of the filings that took place that year. And we have 31 administrative staff. So we are completely buried in this work. And obviously, I'm looking at the 2 folks who are on appropriations as well. We will have a resource ask to help with what's already occurred. But going forward, Kim will be talking now much more positively about this bill. We appreciate you putting it on the table. And thank you for having us in today. So thank you so much.
Very welcome. And Senator Norris already has a question.
Good morning, Tim. I already have a question.
Oh, no problem.
Now, when you say 70,225, you mean 70,225 individuals or cases that have been filed, maybe from less than 70,000 people?
So it's orders. So they would be relating to individual cases or dockets. The two are kind of interchangeable. But basically the way it would work is a judge would send out an expungement order. Let's say that you were found not guilty of a crime. That would result in an expungement order. And that would be sent to our office, to the law enforcement agencies. And then we would have to comply with that order to delete the relevant count or full file, depending on the way the expungement order came out. But it sort of depends. It could be one count in a case, or it could be a full file related to a case. And Kim can get into that a little bit more, but it actually depends because expungement and sealings technically relate to the counts within a case. But the orders are a singular document. So one order could say counts 2 and 3 relating to Mr. Norris shall be expunged because the finding of not guilty at trial. And so then they would be, deleted physically from the record. But it isn't individuals; it's actually counts within cases.
Thank you.
Thank you.
Good morning, everyone. For the record, my name is Kim McManus, and I'm here on behalf of the Department of State's Attorneys and Sheriffs. As Executive Director Luder Dumont stated, he has lived and breathed the history of this bill for the last few years. So he is absolutely our historian and backstop. So he will close our testimony if he feels that anything's missing, or if you want to dig in. I don't think anyone wants to really relive the history, but if anyone does, Tim is here for us to do that. And also, if we need to speak further on the impact of expungement orders on our department and or the connection with court backlog, and can close our testimony in those two areas. As Tim stated, we are so appreciative of this committee taking up this bill. We know we just want to state right off the bat, we appreciate your willingness to work through this process of moving the management of our criminal records from a very complicated expungement and sealing structure to a more streamlined, easier to understand sealing-based system, and easier to understand not just for those of us in the criminal justice system, but for those who interact with the system, both defendants and victims. Looking back through the years of conversation that have taken place about moving towards the sealing system, what we greatly appreciate in S12 is that we feel like you have heard our concerns about expungement. That expungement, the destruction of records, harms defendants and victims alike, that it diminishes government transparency, that it is a drain on the resources of all the entities that need to respond to the expungement orders, that expungement of records creates very complicated situations for prosecutors who are not able to fulfill their duty to produce discoverable material, exculpatory or inculpatory, as required by the Vermont rules of discovery and by our federal and state due process requirements.
Just to, sorry to interrupt you, just definitions for some new members, inculpatory versus exculpatory. Can you just provide some context on what that means and how that could potentially be contained within expunged records?
Sure. So, and I always have to double check that I get it right when we do them. So, exculpatory would be going towards, would be favorable to the defendant. And Tim, correct me if I mix my terms up. So something in a past record that may help the defendant prove that they're not guilty. Inculpatory would be evidence that we would share that is against the defendant, where we may we are required, right, to share with the defendant both with everything in our record. We're required to share with the defendant, including credibility issues of our witnesses. So you often have heard Tim and others testify to Brady Giglio issues. Some say Giglio. I never pronounce it correctly. I apologize. So when those records are expunged and destroyed, we may be aware of the record, but we cannot disclose the record.
And Tim, if I just could, the one way to remember it, because this committee, I think, has dealt with these issues before, and I was looking at one of my notes on this in the past, exculpatory evidence is evidence favorable to the defendant in a criminal trial that exonerates or tends to exonerate the defendant of guilt. So exculpatory helps, I'm just going to say what my law professor did, escape from consequences because you're not as culpable. So you're exculpatory. So it helps you escape. The inculpatory definition that's often used is shows or tends to show a person's involvement. So inculpatory, involvement in the case. So the two, involvement and exculpatory, have the inverse meanings.
Thank you. And just one more clarifying question. So a Brady Giglio letter, if that is in a record that's expunged, that's basically a letter saying that a specific law enforcement officer is not credible, and that record is being destroyed. That documents that Brady disqualification. Is that right? Or
if I could take that one, Kim, just to say that Brady Giglio is not just letters, it's the entire body of material, including criminal history records, phone calls. It includes, like, if a prosecutor decides to do a letter, but that's just one example. If I left a voicemail saying to somebody, hey, I really did it, right? And then, that was never disclosed, but the prosecutor was aware of it, and somehow someone else was blamed for the crime. That would be Brady Giglio material. Those are the two cases that established that impeachment evidence and exculpatory information, things that you could either impeach someone on the stand for, or that would tend to help with guilt or innocence. Those categories need to be disclosed to defendants. And so in an expunged record, for example, someone with a false information to a police officer, someone with a simple assault charge, something like that, if that's not disclosed, let's say it's a witness in a case, and that hurts the defendant, but we're aware of it, we had to delete it and say it doesn't exist. That's how expungement currently impacts our discovery obligations. And Brady Giglio is just a part of that. It's just the two Supreme Court cases that we often reference, and that prosecutors often reference when they're talking about the letters where an officer has done something. But Brady Giglio relates to the entire spectrum of our responsibility to disclose exculpatory information and other discoverable information to defendants.
Thank you. One quick follow-up, and then Senator Hosky, and then we'll get back to you. So in other words, it seems like it creates kind of a tricky situation when you're required to disclose Brady Giglio materials. The defense says the defense requests that material, which you're required to disclose, but then you have to say no such record exists, even though you previously know it exists, but it's just been completely destroyed, right?
Yeah, it's actually us running state laws running up against the discovery. It's like they're two battling laws, and if we've complied with the state law, we're actually in some ways offending constitutional due process notions, right, of making sure we're disclosing everything that the defense needs. Also, deletion of victims' interactions with the situations, but that's not Brady Giglio. That's just another topic.
Senator Hosky.
Yeah, I don't believe we actually ended up standing up a Brady Giglio database. I know we talked about it a lot when I was at the House, but I wonder if where the intersection between sealing and expungement would come with a database like that. Should we revisit that?
Yeah, so that would only relate to police officers. And again, Brady Giglio is about all of the responsibility. So as an example, I had a witness with a false information conviction who was a witness and a victim in a case. I had to disclose that conviction to the defense. He was not a police officer, but it was still Brady Giglio material that I had to disclose. So that's the type of thing that wouldn't be contained on a Brady Giglio database, because this is where the confusion of like law enforcement oversight and Brady Giglio, which is a conversation for a different day, probably needing to happen in GovOps before coming to you all, so we could do that, Senator Vyhovsky. But basically, I would say that the list might help in some ways for police officers, but not for all the other witness types and other types of information that might be Brady Giglio. And now I'll get it back to Kim. I'm sorry to get everyone off track.
Yeah, that's okay. It's an important part. And again, what we want to appreciate is that by moving from sealing away from expungement, we are mitigating those issues. When we're fully expunging these records, we are creating these issues for prosecutors, defendants, and victims to not be able to access these records when and if they need to. But by sealing them and the way the bill is structured, there is the possibility, right, to go in and find the record when we need to. Lastly, just one point of an issue with expungement is it also disturbs our ability to properly track recidivism data. Records disappear. And then there is a provision, I know, for research in here, but again, with sealing, that means it then researchers can go in and use that data, but if it's expunged, it's disappeared. So as stated, we appreciate that you picked this up from last year and that you've heard our concerns about the current system of record management, and then we're moving forward to almost exclusively a sealing system. And the state's attorneys support this move towards the sealing system. We believe that the sealing of records properly balances the ability to remove the stigma from individuals who have had criminal justice contact and who wish to move forward in their life for housing, employment, and whatnot, but balances out the criminal justice need to access these records when needed. for certain qualifying offenses.
And that's where a question of mine comes in, housing, employment, et cetera. So, Office of Professional Regulation, for instance, that's a place where I have concerns where we're continuing to impact somebody's professional career, even though the offense is on a list that we've already agreed can be expungible. They've already gone through their punishment phase, they've gone through the statutory waiting phase, and now their records would be sealed, but OPR, if they go to get a professional license, can look at those records. What's your position on that piece?
Well, I'd want to be very careful since representing state's attorneys and sheriffs, we're focused on law enforcement and state's attorney's access to these records for criminal justice purposes. So I would leave to OPR and the other licensing professionals where there might be issues. I mean, it would be understandable that there's certain professions that you might want to know certain, even though they're on this qualifying list, that whether it be childcare or law enforcement, military, there would, I think it would be something to carefully consider, but we don't take a position on that.
Thank you.
Yeah. And I do appreciate that large part of the puzzle.
Senator.
I hate to get in all these questions before we get
No,
going here, Kim.
That's why we're here.
Did I hear Director Luan right when he was speaking about if someone's charged with something and found not guilty, that record still exists? So if I was doing in law enforcement terms, 29C or a records check, I could have 10 cases there and 8 of them would be found not guilty. And I guess my question is, wouldn't that eliminate a lot of the process of expunging if we said, why is that record even there? Someone's found not guilty on a records check.
So, I mean, the current bill would seal those records, is my understanding. And is your question, why is it we'd even want that seal?
Why is it even there? If we could just eliminate that sealing process, if someone's found not guilty, why does that even exist on their record?
Yeah, so there's a distinction between the law enforcement record and the like the court interaction. And so the court interaction is what we would be concerned with sealing in terms of like if you were the law enforcement officer that arrested someone, that the point is that we're not having to delete the fact that it took place, because if you were the defendant and you wanted to actually say, Attorney McManus, I was just found not guilty, give me my records. I need to show my employer that I was found not guilty. And we say no such records exist because we've deleted them. It's actually better to seal, because then we can hand you your record saying this is sealed. You're the person that can actually use this, because you're the person who was involved. We're the entity that was involved here. So it's actually better for us not to delete that record so that you can, if there was a Facebook post about you or a press release post about you and you're found not guilty, it's better that we're not deleting that so that you can actually prove, hey, I was found not guilty. Because otherwise it's a bit absurd for you to come to our office and us say no such record exists when you sat in front of 12 members of your, county jury peers and they found you not guilty. So that's the government transparency side of this too. So we even in that case, sealing is much better than expungement.
If I could provide another example, Senator Norris, often there might be civil suits that are running parallel to the criminal issue. So, if say someone went to trial and was found not guilty, right, the standard is reasonable doubt, right? On the civil side, it's a lower standard of evidence. Often either the defendant or the victim would want to access that probable cause affidavit or some of that information for their civil suit. So we often are asked for those criminal records when that occurs. I was just reading about a case in Maryland just last night where it was a sexual assault case. The defendant was found not guilty, but the family was suing the defendant in civil court, and the victim was in a coma. And so they needed information that was in that criminal record. The victim was not going to be able to testify. I don't know how the whole case shook out, but essentially it was they had to go through the process, and it was a sealing system there. So they were able to go through the process to request that the seal be broken, essentially, so that the the plaintiffs could access that on behalf of the victim. So that would be another example. So we are, again, very pleased with the direction that this is going in. We do have one issue that we want to raise today. We have concerns, and this was a concern that we raised last year, about the 10-year period, that after that 10-year period, that look back period, that then it is sort of, we've been using the term super sealing. So I'll use it again since I think everyone's been using that term. That super sealing, and this is in Title 13, Section 7607B, and that's on page 25, starting at line 16. This allows, again, so the record has been sealed, and it allows law enforcement and the state's attorneys to have access for 10 years for our legitimate criminal justice purposes. And then in essence, after that 10 years, from our point of view, even though we're calling it sealed, the effect is that it's expunged if we can't access it for all the reasons that we ran through why we don't want the records expunged. So we have concerns about this look back period. Ideally, we would prefer not to have any temporal limit on when we could access these sealed records for all the reasons we've run through. If this committee feels strongly that there needs to be a limit, we would ask that that be 20 years instead of 10 years. We believe that while there would potentially be the stray case that fell outside of that longer period would address the bulk of our concerns. We also have parity to that time period on the DMV side in Title 23. We have a look back of 20 years, so we see some equity there across the board.
So you mean 20 years after the person has gone through the process and completed their sentence and paid their fines and their surcharges, so it would be more like maybe 25 or 30 years.
Correct, right? Depending on the scenario. It could either be the scenario where there was no conviction, right? And then it's everything sealed, I believe it's 60 days after, or there was a dismissal, right? So it could be 20 years, take 20 years, if that's the situation. It could be longer if somebody served a sentence, served their probation, once they're eligible under the rest of, whether it's 3 years or 7 years, right? Once that eligibility. So we do appreciate exactly that the time period would range from 20 years up to 27, 28, depending on the scenario.
So one of the problems that I've had over the last couple of years, and Tim has been there for all of this. So Tim began by talking about the flood of expungement orders that are coming in. And you guys are at that. The whole system is being buried in those. So the law right now is expungement, where there's zero access for anybody. The records are gone. And every time this bill crashes and burns, that gets worse and worse and worse. And what is preventing the bill from going forward is, to my mind, that the administration and related powerful agencies like state's attorneys and sheriffs are essentially always moving the goalposts out further. So now to talk about having 30 years before somebody can expunge an offense that we agree is minor enough that it should be expungible, it just strikes me that we're moving off in that direction again. And it's, I get disheartened when we're doing that, because I really want this to pass this time around. But last time I felt that the administration came in with a whole long series of asks for access to the ceiling. And everybody can make a logical reason, but I would just ask us to return to the basic proposition that if we do nothing, these are 100% expunged. nobody has access, not a judge, not the police, not the journalists. So this bill, it seems to me, is trying to strike a middle ground. So I'm just hoping that all the parties involved will moderate their expectations, because they should be compared to nothing. Like, so if it was, you had to serve your sentence, pay your fines, wait 10 years, then there was another superseding period. That seems to me like quite a lot of give from where we are now. But to add another 10 years just seems sort of, notional to me. Like, let's not compromise at all. So I know you come in good faith to talk about this, and I know we're not done with that talk, but I do want to just set that baseline that what Tim was talking about, those cases burying us, it's because this crashes and burns. To my mind, that's because we're being presented all the time with these, compared to nothing, extreme versions of what a sealing regime would look like in terms of everybody having access and the person's records not only not being expunged, but available to everybody for 30 years down the road. That's not a fair trade for what is in law now, seems to me.
And if I might just on the little bit there, I did present this exact same 20-year piece during the discussion last year. And also I agree, the access shouldn't be for everyone. It should be for the limited purposes that your bill, already eloquently states. But I appreciate that. And, I think for us, we wanted to make sure we talked as a group of all the state's attorneys in September. And they wanted me to represent that 20 years was the period that they wanted to talk about. And one of the reasons, right, is because every day in our courts to move cases, we're doing dismissals. And right now, a dismissal could occur the day after a case is filed. And so that results in a form of, if it's dismissal with prejudice, that's expungement. And so that is a tight 20 years. And we're doing that as a part of plea agreements every single day in our courts. So I appreciate what you're saying, Mr. Senator, but I also want to make sure folks know that from our perspective, we're not talking about access for others. We're talking about just our criminal justice purpose, and the sort of parity with Title 23 with the 20-year look back for DMV related activity was sort of the policy basis. But I mean, again, you are the policymakers and the lawmakers, and we'll comply with the law however you decide to proceed. But we wanted to make sure you were aware of the perspective.
I will also just add, I mean, it's my opinion at the moment that I don't even know if super sealing is something that we actually need, or if we can just figure out a more narrow and clear version of, once a record is sealed, who has access to it. And, is it just a narrow few entities such as state's attorneys and defenders and the defendant? In my opinion, I think that's reasonable. And I think that the super sealing, it can be this concept that we get kind of caught on as you've described. And I think it's also something that will create more work, more administrative work that I don't know is necessarily going to be impactful in one way or the other, but that's my current thought on it. Senator Wachowski, and then
Could I,
yes.
sorry, just on the same topic, in case the question steers us in a slightly different direction, I just have one other thing.
Mhm.
And as Tim said, completely appreciate what you stated. And we would just, from our department's point of view, be remiss if we didn't raise that issue of the 10 versus 20 years. And I did just want to point out, the current bill allows defendants access to their records forever. They're not limited by that 10-year point. And we would wonder what scenarios then the defendant have access, we reach that 10-year mark and we don't have access, or we're dependent on if the defendant is filing a lawsuit against the state, if the defendant is suing the victim, if the defendant is publishing a book or a movie and we need to, do we need to ask the defendant at that point for the record? Or is there a mechanism, whether there's a time limit or not, like, where can we make sure that that has some equilibrium? Because that feels unmanageable.
Yeah, I just want to say I agree with Senator Baruch, that we're taking away what someone expects right now, which is nobody has access. And so I want to be really narrow and thoughtful about how we do that for these offenses that we deem currently expungable. I'm also curious, Tim, all 14 state's attorneys support this bill as it is in front of us.
No, so the state attorneys support moving to a sealing regime, away from expungement towards sealing. And right now, just as a reminder, it's a split. So there's some things that get sealed, some that get expunged. State's attorneys support moving to sealing. And so we're supportive of bills like this that move to sealing, but I think I can very rarely say that all state's attorneys represent this or that, but in this bill, if there was a greater time limitation, which is what we also testified to last year, just from our department, I think it would probably have the full support of most of the state's attorneys. Sometimes you don't get all of them to respond to everything, as you know, but yeah, I think the sealing system, going to a one-track system in general, is going to help our offices.
That makes a lot of sense. And so what I'm hearing, sort of as we get into the details, it might break down a little bit, but the general idea is supported.
Yeah, exactly. The general idea. Yep. Thank you. Good clarity.
Yeah, a quick question, Kim, not to leave you out of this picture here. So we talk about sealing versus expungement. From a time issue, are they both about the same as far as the effort that the courts and state attorneys have to put into as far as expunging them versus sealing them? Which is quicker, if any?
Sealing, and Tim can speak further, but expunging, like, you need to eradicate the record. You need to, if there's a physical file, that file gets shred. All the digital files need to be removed from from our office, from the sending law enforcement agency, from the court, right? Has to gather that information and make sure it is destroyed. Versus sealing, it's separated and sealed, but we don't have to go through.
Stable, we're good to go, right?
Yeah, like, whatever the physical manifestation of that is.
Okay, so in the interest of time, I'm not going to ask the other questions that I have because we'll be discussing this more in reference to Senator Bruce and the host response. But thank you.
Yeah, and just lastly, one last point just on, and as you indicated, there are issues around the super sealing in general. We recall last year that the Department of Public Safety raised concerns just about the logistics of being able to do it on the Crime Information Center. And so we know that you'll want to hear from them because we are concerned about just the actual operational side of being able to do that.
One quick question. At least when I checked over the summer, I believe back then, we were the only state that does expungement the way we currently do, in that we completely destroy the records and deny their existence. Do you know if that's still the case?
I believe that is still the case, and Tim can verify, but at least as of our information is 2021, 41 out of the 54 jurisdictions basically only do sealing. And then even when they use the word expunge or expungement, it's not actually expunging, it's sealing.
Yeah.
But Tim, is there anything further on that?
Yeah. Our wonderful appellate attorney who is elevated away from the wonderful work of legislative activity, Evan Meenan, but back in 2021, he did a pretty exhaustive survey, which I blanketed your website last year with all of our prior work. I won't do that again, but it is on your website from last session. We did a survey and a PowerPoint a couple of years ago, and that's the findings that he came to was essentially as you described, Mr. Chair.
But we're not aware of any change. There could have been a change in the last few years, but we're not aware of that.
Yeah, I didn't see that over the summer. When I was trying to prepare for the session and saw the writing on the wall that we'd be starting with sealing and expungement. I started looking to other states to see what they did, and then I realized, yeah, we're literally the only state that completely destroys the record.
Yeah.
State.
Mr. Chair, I wondered if I might just say if there's it's always hard to negotiate with 14 or 28 elected folks, as you all know from your work. But if there's pieces that you all want Kim and I to try to survey or talk with the state's attorneys about on this bill, we are more than happy to do that, or with the executive committee, kind of a tighter group of elected folks by the state's attorneys. And you know, we appreciate you taking the time this morning with us and taking up this important topic.
Tim, I think one thing that I think might be helpful is getting some more information, perhaps anecdotes about when law enforcement reaches out to you to get sealed records. Well, actually, no, let me correct that. So law enforcement can currently access sealed records, right?
Did you say the word can or can't?
Can. They do have access to sealed records currently.
That's correct. That's correct.
Under all circumstances.
It would be only for criminal justice purposes under the law. So the same access that we currently have. The way that it physically works, and Kim and I were talking about this, I think there's maybe one office, maybe it's Chittenden with Valcor access, but the way our offices are essentially resourced, we don't have Valcor portals or Valcor access in our state's attorney's offices. And so we actually rely on law enforcement to send us criminal history records when they're doing cases, as you may recall from your time as a trooper, or you, Mr. Sheriff, as well. The state's attorney's offices receive records from law enforcement. And so we don't have, for the most part, our own access. We're actually reliant on law enforcement to send us criminal history records.
Senator Hoskin and Senator Norris.
What's the legal definition of criminal justice purposes?
It's the relating to the, I remembered, I think I memorized it last year, Senator, but it's essentially the investigation and adjudication, everything from like the investigation through sentencing, right? And that in part helps cover some of what we talked about with like Brady Giglio, for example. So a sealed record could be used at sentencing to help a defendant. It could be used in investigation phase. For example, if someone on the public record said they've never had a simple assault interaction, or they've never had an incident where they had a gun present, something like that. In the Valcor record of a sealed record, right, the officer could communicate to us, this person has had 50 interactions with us and actually a few charges. So we're going to make sure that we send a third officer, and we're going to request, you know, that there's certain conditions to make sure a victim is safe or something like that. So it's helpful from investigation through sentencing, and that's that scope of criminal justice purposes that we're currently using right now. That is so important to how we're currently using sealed records. But again, as the Mr. Pro Tem has pointed out, some records are expunged and some are sealed, so our use of them is varied. But we're reliant on law enforcement to, for the most part, generate those records for us to consider. And sometimes, like in the middle of the night, is where it's the most acute, where you're 3 a.m., you get a call from an officer, and you're trying to figure out how best to move forward with the case.
Two follow-ups to that. One, would that apply to just a roadside stop for speeding or a tail light being out? Would that be criminal justice purposes?
It would, if that turned into a criminal justice, like if that was just you're speeding and it wasn't criminal speeding, then I don't think that wouldn't be a criminal justice purpose. That doesn't have to do with a criminal case. If you get a roadside stop and it turns into a criminal case, then it would turn into criminal justice purposes potentially, but it would depend on how that would flow, right? So if it's tail light out, you get a ticket for tail light out. No, that's not gonna, there's going to be no sealed records usage for that because that's not in the scope of criminal justice purposes. But if it's, speeding away and yeah.
My other question, and it was a question I asked yet, or sort of brought up yesterday, and it's around confusion for the person whose record is sealed. So you brought up if they say, nope, don't have a criminal record, but you then look up and say, oh no, they actually have a sealed record for a simple assault. Are they then in trouble for lying because they thought they could say, because under the expungement rule, you get to legitimately say, nope, I don't have a record. But now we're creating a system where you can say that to some people, but you can't say it to others. So how do you navigate that?
So, I mean, it's a really good question. And I think the most important thing is, except for if you have another criminal justice interaction in terms of going down to, as all the things that Mr. Pro Tem had just mentioned, your housing, your employment, those types of things, you can absolutely say, I do not have a criminal history and I do not have a record in terms of this. I mean, if it's a complete, they don't have a record, then I think that's that balance that Attorney McManus was talking about, balancing the benefits with making sure, as the most extreme example, but the girl that was found in New York who had been kidnapped, and they used a 20-year-old sealed DUI record to locate the person's address when they found her. Like, that's a criminal justice purpose. And even though the underlying crime was a DUI, that helped locate that girl in terms of finding the location of someone with the prior sealed record. And so if that was his only record, for example, in New York, he could have claimed, I do not have a criminal history, right? But it was used for that criminal justice purpose to find that person. So for me, that's that balance that we're trying to find. But I think it would be that they don't have a criminal history unless something comes through where it's being used for that purpose. And I think I'd want to think about that a little bit more in terms of how, we would maybe talk about it. But I think the statute may say currently for both expungement and sealing, no record exists, right? For public records requests, right? If we got public records requested for something, no record exists. If I got asked the question on the street by a reporter, no record exists. But if it's a law enforcement investigation into something very serious, we're going to consider it to make sure that we're considering safety, and maybe it helps the defendant too. And that's the thing that I think we often, not you all, but often I think the public sometimes forgets, is when we're deleting someone's criminal history, we're sometimes deleting their interactions with law enforcement, which maybe they want to say at sentencing. Hey, this police officer, I've had bad interactions with them. Look at all these interactions I've had with them. And if we're deleting those interactions, that's something that I think isn't good for transparency purposes for defendants who want to talk about what they've been through.
I think I also just wanted to add, for running the background, on the roadside, that's, and Senator Norris, have to get your input on this too. I mean, that's something that, from my own experience, you'll do it maybe 1 out of 10 times, and by the time you're asking dispatch to punch a case, at that point you've got probable cause. You've seen the heroin bag is on the floor, or you've seen that the person is clearly intoxicated, and you're going to be screening them. And you have dispatch putting in all that information into the computer, and when you're on the roadside, you're not going to be going through that lengthy, or perhaps not lengthy, criminal record, and thinking to yourself, oh, I see a petty larceny from 15 years ago. It's really not going to impact an investigation when you're already, at that point where you're punching the card and running the 29C. That's just my own experience there. But I think there could also be some, regarding the second point regarding, false information, or the fear of providing false information. I think there could be, perhaps a provision that we put in there that makes it clear that if somebody has a sealed record and they say to law enforcement, or they're testifying that I don't have a record because it's sealed, they're not going to be liable for false information, or specifically that statement. So that's just 2 thoughts. But Senator Norris, you had your hand up.
Oh, yes, real quick, so Tim can get back to her presentation. I found that chart last year, Tim, to be very informational. You said it still exists on our page.
Yeah, I'd be happy to resubmit it. as well.
If you would, because I'm sure that Senator Matos would find that it says a lot of things that what are the states do who has access to and so forth. And on my final note is, I believe that there are certain counties, and I think Chittenden County may be one of them, that does have limited access to Valcor for courtroom purposes. I don't know how far they can go, but they don't like killing a lot of trees in Chittenden County, so they'll allow the courtroom to flow back and forth through Valcor from law enforcement agencies. Or I tried to get that in Franklin County actually, but it wasn't met with them.
I believe you're correct. I think Chittenden's State's Attorney's Office does have Valcor access. I believe the vast majority of the other State's Attorney's offices don't. There may have been a time in history before Valcor, right, where there was more investigators and stuff in our State's Attorney's offices, where there was more of this type of activity, but we're in the digital era right now, so things are in that space.
Thank you.
Kim, was your testimony concluded? I thought that it was.
Yes, I was going to say, I appreciate Senator Norris thinking that there was a lot more, but there is not. And, you know, our takeaway for today is we support the vast majority of S12. We do want to continue talking about the super sealing part, and we appreciate your concerns and hope that we can maybe find some place in the middle that addresses our needs to access the records while addressing, you know, you wanting them to be done at some point. But yes, that is, so any other questions, we're happy to answer, but.
Just a point about the roadside stop piece, and I take the practical experience point that generally speaking, somebody's not going to have the time or the desire to be going through that. I would just ask us to keep in mind law enforcement gone wrong. So somebody who's stopped someone who is a minority, somebody who they maybe with malintent or unconscious bias are very suspicious about, and they do go through all the record looking for something to get on a person. This is why, in my understanding, we don't to this day have primary seatbelt enforcement, because it can be used disproportionately to disadvantage people of color. That was always the argument that was made for not having primary seatbelt enforcement, was that if it wasn't going to provide enough benefit to have it to outweigh the possibility that it was used against certain people. And I worry that under the sealing regime that we're talking about, where roadside stops would have access to sealed material, it could be used disproportionately against certain populations. So, you know, the driver is, you know, a white male, 55, looks very similar to the officer doing the arrest, then we don't need to go into that. But if the person looks different, I'm suspicious, I'm going to go through all that sealed material and it will have a different impact.
Yeah, and that point is well taken. What I wonder about is, I mean, law enforcement currently can access sealed records, but if we were to change it in such a way that, instead of just creating this whole new super sealing regime, just having it be that if it's beyond 10 years, and let's say it's a very complex investigation, not just a roadside DUI, but it's, maybe a cold case or conspiracy case, and some detectives need to access sealed records that they're confident exist, then they can reach out to the state's attorney and say, can you guys go access these records? And they can do that. I think that could make sense in order to alleviate the concern that you just raised. So, yeah, let's put that out there. Senator Close.
I appreciate we're trying to find the happy medium, and I take your point that officers can currently access sealed records, but currently there's a bunch of expunged records they can't access that we're considering adding to sealed records. So I think there is concern for me in saying, well, they can currently access sealed records, so they should continue to be able to access sealed records while we're adding a bunch more to those sealed records.
So I think if those expunged records that can't access are moved to the sealed category, but only accessible by the state's attorney, after law enforcement says, here is why we need access to this, because we're doing this massive drug investigation or we're solving a cold case, not just for the roadside DUI. I think that could be a remedy for that.
Yeah.
So,
And with your earlier question, one thing that we can do on our end is to gather up more concrete examples of when law enforcement are going in.
yeah,
To look at field records to bring to you, and talk through, if and when, it is used at a roadside stop versus a more, long-term investigation. And I would just add the example that you brought up, Senator Bruce, is another reason why we would want, say, that roadside stop, say it led to a charge, led to some conviction. If that officer had a pattern of behavior like that, but it took years for that pattern to be developed, that is a reason why we would want those records to be available, right? To be able to go in and
Yeah.
look at all of those stops. So that's that counterbalance exactly right there.
And I think in one way, what we're talking about is we determine there the need, it's in a different category from a casual roadside stop where, I might as well see if there's anything there. So the Senator Hopes called it a happy medium. And I think that's what we're all pointing out in different ways. There are valid reasons to have access to the records, and that there are, in my mind, ones that are not necessarily valid or that are outweighed by the needs of the defendant. And I feel like this bill is moving in the right direction. I have my concerns about it, and I know you all have some. So we'll hopefully get there.
Yeah, and we're happy to come back again and speak more directly to that, when and how officers are accessing sealed records so that can inform your decisions.
and before I forget, I think, I just asked Kayla to reach out to Jeff Wallen from VCIC. I think I'm remembering now that perhaps there might be some issues that he raised last year. I mean, it was a year ago, so I don't remember, but regarding super sealing. I think it would be great if we could get to a place where, as I described earlier, if it's beyond 10 years, law enforcement just reaches out to the SA and the SA can go through the process and make a motion to get the sealed records.
Yeah.
But yeah, hopefully that is technically possible with the Crime Information Center. So that being said, we're at 10 o'clock. We have.
Mr. Chair, I just wanted to say, I did not purposely avoid coming over today, but I did have the flu on Monday and didn't want to act in front of you. So thanks for letting us do the split combo here. And I didn't want to expose you all because I know there's already been sickness running through the building.
We are going to check your sealed records to see this other meeting.
Let's talk about the.
That sounds good. Thank you. That'd be a limited purpose item I would consent to.
We can also tell the FBI that records have been sealed.
For more records.
Yes.
Okay, yes, but we can't.
Judge, do you mind if we take a 5-minute break and come back?
Thank you very much.
Thank you for your testimony.
General.
Right.